Recently, we had a case involving a very significant motorcycle crash, and our client suffered significant orthopedic injuries and some mild traumatic brain injury. And the police report indicated that he himself was at fault, meaning our client was at fault. Well, I wasn't buying that, and we did not agree to just lay down. So we did some further looking into the case, and then we found out that, unfortunately for our client, he was hit by an uninsured drunk driver, who, as a result of this case, is now residing in prison. However, that doesn't help our client pay his bills. It doesn't help him feed his family, etc. He had a very good health insurance plan that paid for all of his bills, nearly $200,000 in bills. Now, if you recall what I said, because this was an accident and there was other insurance out there to pay for his injuries and medical bills, now the subrogation clause of his health insurance kicked in, and so that meant that they wanted payback of $135,000. We ended up settling our client's claim for his policy limits in his uninsured motorist provision for $250,000. The claim was worth, we believe, around $500,000, but the defendant didn't have assets. The defendant didn't have any type of insurance, and our client only had $250,000, which is still more than the average person gets, but nonetheless, even $250K was not adequate to properly compensate our client. So the long and short of it is we ended up settling this case. It just so happens, timing-wise, that once we settled the case and we had the insurance check residing in the law firm's client's trust account, we get notice, we meaning the law firm gets notice that they intend to get paid back of $135,000. Well, I contact them and I say, sorry, it's too late. And so they wrote me and they said, well, we indeed do intend to pursue this, and we suggest you read clause, whatever the clause number was, with regard to subrogation. And I said, sorry, but you're non-ERISA. Well, come to find out, they in fact did produce to me a questionnaire that was filled out by our client that our client did not recall filling out. And he happened to fill out this questionnaire while he was still in the hospital while under the influence of morphine. But nonetheless, their argument was that they indeed had notice. So that was a valid point. Fortunately for us, the timing of this notice, the money was still in our client's trust account. So now it was our opportunity to end up dealing with this law firm to see how can we minimize this subrogation payback. So the only thing that we can do is to get that money compensation into that person's hand to make their life as easy as possible. So then we end up dealing with this national, well-known law firm, and then they give us a counteroffer. And what they propose is, because what I said at first is, I'm sorry that we're not going to pay you anything. Well, that argument was kind of washed away because little did I know that they actually put our client on notice. So that was a problem for us. So we knew that we had to pay back something. But because it was a non-ERISA plan, then we were planning to fight. And if we had to take it to trial to fight, then that's what we do. So his first proposal was we take the $250,000 settlement and we divide it by 3, meaning they'll accept, of their $135,000 lien, they'll accept roughly $83,000. Our client gets $83,000, and the attorneys get $83,000. And I told him, with all due respect, you're a fine Southern gentleman, but there ain't no way I'm doing that. And anyway, so they re-looked at it and they decided, well, all right, well maybe that was a bit much, and so they agreed to for our client to pay them $30,000. You know, first they wanted $135,000. And had we just said yes, like unfortunately some lawyers would have, because they just don't deal with that aspect of it, you know, once again, because remember, lawyers aren't paid for that part of it. I would think that most attorneys do try to not only maximize what one gets, but also minimize payback. So, so had they not been represented, God knows, you know, what they would have had to pay back this large health insurance company. I suspect that they would have had to pay the entire thing. So anyway, they came back to me with, all right, well, rather than $135,000, and then rather than $83,000, we'll agree to $30,000. Now, had we not pushed it or pressed the buttons, then our client would have gotten $50,000 less. But we pressed the buttons, and really, you know, for what they paid out, and frankly, part of the reason why the claim settled for what it settled was because of the medical bills. But I represent my client. I don't represent the big insurance company. And even though I thought 30 was relatively fair, the insurance company won't have to live with this issue the rest of their lives, but our client will. So I said, well, you know, I do appreciate the offer, and I do realize that this is your take it or leave it, but we can live with $25,000 payback. So rather our client netting out peanuts, if you will, for what he had to undergo, he at least was able to net out roughly $160-some thousand, which he would rather exchange not to have his headaches, not to have his ongoing lumbar spine pain, etc. But you know, we were able to help this person maximize the money that goes into his hand, and he was able to pick up the pieces of his life just before Christmas. The mortgage company was about ready to foreclose just before Christmas, and so we were able, timing-wise, it just happened to work out fine, and he was able to get back on track, and now he's going to move to South Carolina with his daughter, and they've got some plans, so that was very satisfying to me. And you know, when we can do that for some clients, then it makes me feel good too, because I've done my diligence. I've done what I was hired to do. I wasn't hired to do a quick settlement to get as much as I could get just so I could get paid. Of course, that's part of it. You know, I can't do this for free, just like people don't go to work for free. But I think because of our experience, you know, we were able to convince the insurer to pay the maximum on a claim where the police said our guy was at fault. But most importantly, it was because of our long experience in terms of just being tenacious with regard to dealing with the health insurance and the other liens. And by the way, on this same case, he also had a short-term disability lien through another large, well-known insurance company, a good company, but even though that was short-term disability, they have the big print giveth and small print taketh away as well. And we were able, you know, to convince them to accept, you know, peanuts.